Good evening, everyone. My name's John Kiernan. I'm president of the New York City Bar Association, and it's my pleasure and delight to welcome you to the 14th annual Ginsburg Lecture, and not coincidentally, 14th consecutive sellout, putting this event in its own way in the august company of the 1970s New York Knicks, Billy Joel at the Garden, and some of the hottest tickets on Broadway. And it's great to have all of you participating in such a terrific event. The City Bar established this lecture series 14 years ago in an effort to celebrate Justice Ginsburg's groundbreaking achievements as a lawyer, a scholar, and a judge, and her extraordinary contributions in particular to women's rights. And Justice Ginsburg has honored us with her presence at each of these 14 lectures, and has been, including being very significantly involved in the selection of each year's speakers. Justice Ginsburg, you've long been an energetic and loyal, dedicated supporter of the City Bar Association, going back all the way to your service on the Executive Committee from 1974 to 1978, and forward to contributions as recent as your terrific participation with Justice Sotomayor in the inaugural Barbara Paul Robinson event last fall. We've been tremendously grateful to you for that, and your substantive contributions are complemented by your enormous contributions as a mentor and a role model, making it particularly a pleasure to welcome the more than 100 law students we have here at tonight's event. It's not an accident, Justice Ginsburg, that your portrait is placed at the dead center of this room. That placement is just a small token of the association's deep esteem, appreciation, and recognition of the enormous role you have played to the advancement of the rule of law, the protection of the vulnerable, and the advancement of the fair, orderly, and efficient administration of justice here in New York and in our nation and around the world. Our speaker this evening, Professor Patricia Bell-Scott, represents a particularly terrific choice as this year's lecturer. She has the unusual capacity to be able to speak to us and present to us two important voices in the development of women's rights particularly, and human rights in general. Her own voice as an award-winning author and scholar, and the voice of Pauli Murray, the central subject of her most recent book, The Firebrand and the First Lady: Portrait of a Friendship, Pauli Murray, Eleanor Roosevelt, and the Struggle for Social Justice. Professor Bell-Scott is Professor Emerita of Women's Studies, Human Development, and Family Sciences at the University of Georgia, a leading scholar and writer with particular reference to lives, experience, and issues of Black women. She's also a co-founder of the National Women's Studies Association and served for a decade as the co-founding editor of SAGE, a scholarly journal of Black women. She's held professional research and administrative appointments at the University of Connecticut, at the Wellesley College Center for Research on Women, MIT, and at her alma mater, the University of Tennessee. Pauli Murray, the central subject of Professor Bell-Scott's latest book, is someone whose story has not been told broadly, widely, and loudly enough. Among her many spectacular accomplishments, she was not only a member of the first wave of leading civil rights lawyers who participated importantly in using the courts as well as their public voices to advance desegregation, but also one of the very first to contend intensely and earnestly that the same legal and human arguments could and must attach to providing equality to women. The story of an important civil rights meeting held in Washington, D.C. establishment, where women listening to discussions about the evils of discrimination were forced to sit in a separate balcony, provides a particularly vivid illustration of a needed correction that Ms. Murray played an important role in achieving. Ms. Murray was a co-founder of the National Organization of Women. Unsurprisingly, she also had multiple touch points with Justice Ginsburg. Those details, though, are best left to the speaker. It's a huge pleasure to present to you. Thank you all for coming, and please join me in welcoming Justice Ruth Bader Ginsburg to the podium. Now, you know you can lower the podium here if you want to.
Thank you. Please. Thank you very much. Thank you. In 1965, an article appeared in the George Washington Law Review titled Jane Crow and the Law. It was co-authored by Pauli Murray, then a senior fellow at Yale Law School, and Mary Eastwood, a lawyer at the Justice Department's Office of Legal Counsel. The article observed that in no case had the United States Supreme Court found a law distinguishing on the basis of sex violative of the 14th Amendment's Equal Protection Clause. But the genius of the U.S. Constitution, Murray and Eastwood believed, is its capacity through judicial interpretation for growth and adaptation to changing conditions and human values. As examples, the article authors pointed to Supreme Court decisions outlawing state-enforced segregation in public schools, establishing the one person, one vote principle, and declaring the right to counsel in criminal cases appointed and paid by the state for defendants without means to engage a lawyer. The court could similarly recognize women's rights as part of human rights, Murray and Eastwood urged. The climate of the era, they said, was favorable for the court to move in that direction. Jane Crow and the Law was a primer for the gender equality litigation of the 1970s, in which I had the great good fortune to participate. Pauli Murray was on the ACLU's board in the 1970s and a member of the union's Equality Committee. When the ACLU briefed the turning point decision on the equal citizenship stature of men and women, Reed v. Reed, I placed Pauli Murray's name on the brief. Though she was not on the brief writing team, her identification of Jane Crow laws and her roadmap for ending them propelled our efforts. For nearly a quarter of a century, Pauli had a tender friendship with Eleanor Roosevelt. That friendship is traced from Pauli's first sight of the First Lady in 1934 until Eleanor Roosevelt's death in 1962 in Patricia Bell Scott's tremendous book, The Firebrand and the First Lady. The book is a 20-year effort. It is an extraordinary chronicle, informative, engaging, a remembrance of the not-so-good old days, an account that should stimulate readers to press for continuing progress. You have heard about our speaker, and I will not repeat what you have already heard, but I will say of the Firebrand and the First Lady, the author wrote that her aims were to honor Pauli Murray's wish to share with others her friendship with Eleanor Roosevelt, to describe the path they lit for future generations, and to express appreciation for Paulie's aid in the book's development. In meeting those aims, I can attest as a reader, Bell Scott succeeded admirably. Paulie Murray, I believe, would have applauded the way the story is told, and she would have cherished the storyteller. So please join me now in heartily welcoming Professor Patricia Bell Scott to the podium.
Let me begin with thanks to the New York City Bar Association for establishing the annual Ruth Bader Ginsburg Distinguished Lecture on Women in the Law. I am honored to be this year's lecturer. Thanks to Amy Kotz and Lynn Chafrin and Martha Harris for all they've done to make this evening and my participation possible. I want to thank my husband, Charles Vernon Underwood Jr., and so many dear friends and colleagues who are here at this momentous occasion. And I owe an especial thanks to the Justice for her introductory remarks and for the countless times she has called attention to Pauli Murray in talks around the country. The Justice has, as always, set a high standard, and I hope to do my best to follow her example. Now, as far as I can tell, only 5 of the previous lecturers on the bar's website have come from professions other than the law. And it appears from having listened to most of those lectures that most of the speakers have known or have had some connection to Justice Ginsburg. While I'm not a lawyer and I have no prior connection to the justice, I want to pay tribute to someone who fits both criteria. Pauli Murray was a brilliant legal scholar, a practicing lawyer, a pioneering civil and women's rights activist, an accomplished poet and writer of prose, and the first African American woman to be ordained as an Episcopal priest. She and Dorothy Kiernan, another trailblazing lawyer, planted the seeds for what would become the Women's Rights Project at the American Civil Liberties Union, for which Justice Ginsburg would become the founding director. I've examined the correspondence between Murray and the Justice during their tenure at the ACLU's National Board, and the documents demonstrate an ongoing dialogue about sex and race discrimination, as well as a commitment to examining bias in the law. Murray used to refer to the women lawyers who shared her commitment to social justice as sisters in the law. And she considered the Justice a sister in the law. Not only were Murray and the Justice passionate about the law and social justice, they also shared an admiration for Eleanor Roosevelt. The Justice, so I've read, keeps a statue of the First Lady in her chamber at the Supreme Court. Murray, on the other hand, kept a photograph of her aunts standing in the yard with Eleanor Roosevelt on the family mantelpiece. I've also noticed that the Justice has on more than one occasion quoted Eleanor Roosevelt's advice to avoid letting anger, resentment, or envy sap your energy. Pauli Murray liked that idea too, and she captured the essence of that message in one of her personal mottos, which was, "Don't get mad, get smart." The historian Susan Ware was prophetic when she wrote in the introduction to a collection of essays on Murray, published in the summer of 2002 issue of the Journal of Women's History, that when historians look back on the 20th century America, all roads will lead to Pauli Murray. Whether the issue was labor, civil, or women's rights, Pauli was there. And this year has been a banner year for Murray. It marks the 40th anniversary of her ordination as the first African American female Episcopal priest. It marks the 30th anniversary of the publication of her prize-winning autobiography, Sung in a Weary Throat. Her childhood home in Durham, North Carolina, was recently designated as a National Historic Landmark. On May 13th, this coming Saturday, Howard University, from which she earned her first law degree, will award her an honorary doctorate. And in August, Yale University, from which she earned the doctorate of juridical science, will accept the first class into its brand new Pauli Murray Residential College. She is the subject of 2 biographies, several major book chapters, a recent New Yorker article, and the inspiration for several works by composer Jeff Beal, who is the musical mastermind behind the Netflix series House of Cards. Some of these works will be performed at the 25th anniversary concert of the Brooklyn Youth Chorus this coming Friday. Shall I say there's much ado about Pauli Murray? But for our purposes this evening, I want to talk about 4 things. First, I want to consider what aspects of her early life set the path for a career in law. I want to examine some of her experiences as a law student and a lawyer. I want to highlight a few of her many contributions as a lawyer. And I want to offer some thoughts about what we might learn from her life. Born on November 20th, 1910 in Baltimore, Maryland, Anna Pauline Murray was the 4th of 6 children born to William Henry Murray, a teacher educated in the college preparatory department of Howard University, and Agnes Georgiana Fitzgerald, a nurse trained at Hampton Institute. Pauli's grandfather, Robert Fitzgerald, fought for the Union Army in the Civil War, and her grandmother, Cornelia, was the acknowledged daughter of Sidney Smith, a white lawyer from a prominent North Carolina family and a part Cherokee slave named Harriet, owned by the Smiths. 2 tragedies marked Murray's childhood. The first was the death of her 7 months pregnant mother of a cerebral hemorrhage when Murray was only 3. And the second tragedy was the murder of her father at the hands of a white guard in the Crownsville, Maryland hospital for the Negro insane, where he was an inmate. Unlike her siblings who remained in Baltimore with her father's relatives, Murray went to live with her mother's family in Durham. And it is that experience of being reared by racially proud elderly kin who were church-going school teachers, which nurtured her compassion for the vulnerable, her intellectual curiosity, her love of literature and poetry, and her devotion to the Episcopal Church. It was evident early on that Murray was an independent spirit who preferred working alone as opposed to in groups. She was almost always ahead of the curve in her thinking, impatient with convention and bureaucracy, and simply usually smarter than those with whom she had to work. She was willing to challenge inequality and authority figures head on, no matter who they were. Perhaps the first sign that she was headed toward law as a profession came when she filed her first complaint against discrimination over the breakfast table. She was barely 6 years old when she asked her Aunt Pauline, "How come you give grandfather 3 pancakes and me only 1?" And she never stopped asking hard questions, no matter how brash or inappropriate they sounded. Murray loved language, philosophy, and debate, even though she was innately shy and at her best and most comfortable expressing herself on the page. She was a nonconformist in her personal and professional life. She was woman loving, and she refused to accept conventional or cultural definitions of who she was. She was continually challenging the barriers that restricted the entry of African Americans and women into careers such as the law and the priesthood, which were commonly reserved for whites and males. Murray's deepest yearning was to be a writer. However, the demands of life as an African American living in the South repeatedly called her into social action, and that activism would eventually draw her into the practice of law. As a Black child in North Carolina, the law required her to attend segregated schools. Legally defenseless, she fought racial segregation with her conscience. It was the only weapon she had. Rather than ride a segregated bus, she walked or bicycled wherever she went. She refused to go to theaters that seated Blacks in the peanut gallery. She passed up the chance to attend historically black colleges and enrolled at Hunter College in 1928. She graduated in 1932 at the peak of the Depression and joined the ranks of the unemployed. She was saved from homelessness by the WPA and a brief respite at Camp Terra, which was a residential facility for unemployed women in the Bear Mountain area of upstate New York. It was there that Murray first crossed paths with Eleanor Roosevelt. Pauli Murray had three significant encounters with lawyers and the legal system in her 20s that would interrupt her pursuit of a writing career. The first of these involved the University of North Carolina Graduate School and the state of North Carolina, which denied her admission into the sociology department in 1938 on racial grounds. In addition to sending protest letters about the university's whites-only admissions policy to Franklin and Eleanor Roosevelt, the university's administration, the North Carolina governor, and the press, Murray sent her application packet to the NAACP Executive Secretary Walter White and its counsel Thurgood Marshall. She hoped that the association would take her case. They did consider her case, but decided not to take it for reasons that were never quite clear to her. It might have been her politics, for Pauli was certainly to the left of the NAAC leadership. It could have been her temperament, as she was a self-described individualist with a first-class intellect, and her assertiveness bothered the association's largely male veteran leaders who thought that she was too audacious. Or the problem might have been Murray's family history. As a plaintiff whose background included a father who had been incarcerated and murdered in a mental hospital would have not been viewed as desirable for a test case. It is also possible that NAACP lawyers backed away because they were suspicious about Pauli's personal life, her manner, her dress, her close relationships with women, and her ambiguous first name would have been cause for concern. The second encounter occurred in 1940, 14 years before the Rosa Parks bus incident in Montgomery, Alabama. On Easter weekend, Murray and a friend, Adeline McBean, were arrested and jailed in Petersburg, Virginia, charged with disorderly conduct, creating a public disturbance, and violating a state statute that mandated racially segregated seating on public buses. The judge fined them $5 plus court costs. This time, the NAACP agreed to handle the case for the appeal, for it seemed to them that this might indeed be an ideal case in which to test the constitutionality of the state ordinance requiring segregated seating. Murray and Mack went to Washington, D.C. to prepare for the appeal with a circle of elite civil rights attorneys at Howard University Law School. In the group were Thurgood Marshall, with whom Murray had previously consulted on the UNC application, William Hastie, who was now dean of Howard Law School, and Leon Ransom, who was also at the law school. It was a formidable team, and Pauley found the debate during the practice session mesmerizing. Nonetheless, they'd lose the appeal when the prosecution dropped the violation of segregation charge to avert a constitutional challenge. The third incident involved the case of a 23-year-old African-American sharecropper from Virginia who shot his landlord and employer, Oscar Davis, a white tenant farmer from the same area. That sharecropper was Odell Waller, and Odell admitted that he had shot Davis, but that he had shot in self-defense. Waller was convicted of first-degree murder and sentenced to death by an all-white jury of men who had paid the poll tax. It was a case fraught with problems, as Murray, who was hired by the Workers' Defense League to help gather evidence for the investigation and the trial, and to help mount a national campaign to save Waller's life, quickly learned. There was the questionable credibility of the prosecution's only eyewitness, who was a black field hand who lived with the Davises. There was the question of judicial temperament. James Turner Clement, the presiding white judge, displayed a dismissive attitude toward the defense, and his remark that a man charged with a criminal offense has no right to await the action of a grand jury made in the presence of jurors seemed to suspend the presumption of innocence. There was the suppression of evidence indicating that Oscar Davis had a violent temper, regularly carried a gun, and used it. But perhaps the most consequential error was that Waller's initial attorney did not document the jurors and Waller's poll tax status. This, Murray believed, would have been proof that Waller had not been tried by a jury of his peers. Because this error was foundational to Waller's first-degree murder conviction, Murray felt that he was executed because of a technicality. Because Murray was the liaison between Waller's family and his defense team, she followed the case closely as it was argued before the Virginia Supreme Court of Appeals, the U.S. Supreme Court, the U.S. District Court, the U.S. Fourth Circuit Court of Appeals. She watched Waller's lawyers submit separate petitions to U.S. Supreme Court Justices Harlan Stone, Hugo Black, Robert Jackson, and Felix Frankfurter. In the end, their efforts failed, and Waller was executed on July 2nd, 1942. He was the 156th Black man to die in Virginia's electric chair. Only 23 white men had been electrocuted. After Murray's experience with the state of North Carolina, which refused to admit her into the university, her arrest in Petersburg, Virginia, for refusing to remove to the Black section of the bus, and the execution of Odell Waller for what she believed to be the self-defense shooting of his white employer, she made 3 commitments that she would keep for the rest of her life. 1, to do battle with racial discrimination encoded in the law. 2, to challenge the discriminatory treatment of the poor, minorities, and women in the judicial system. And 3, to oppose the death penalty. Near the end of the Waller case, Murray enrolled in Howard University Law School, which was the premier training ground for civil rights attorneys. Thurgood Marshall was an alum, and more than half of the historically Black school's all-male faculty held advanced law degrees from Harvard. There were currently no women on the faculty. Murray was one of 2 women to enroll in the class of 1944 and the only woman to complete the first year. Having been reared by family elders who placed no restrictions on women and expected them to be self-reliant, and having graduated from a women's college and worked under women supervisors in the WPA, Murray had little awareness of sex bias. But her consciousness was awakened the first week of the first semester when one of her professors announced to his class that he really didn't know why women came to law school. But since they had, the men would have to put up with them. Drowned out by the louder, aggressive males, Murray seldom got the chance to recite in class. She was deeply hurt when Professor Leon Ransom, whom she adored, told her that she could not attend a smoker, which was a gathering at his home for first-year male students sponsored by the campus chapter of a legal fraternity. Murray could not fathom how Ransom could risk his life fighting for civil rights in Southern courts and host an event for students that excluded her. That he made light of women's exclusion when she approached him about the issue moved her to think of civil rights as an issue that went beyond race and class. In a letter to the fraternity's president, Murray raised the question of equal opportunity for women. I have no right to quarrel with the policies of your fraternity if the objective of the fraternity is purely social and has no interest outside of that field of relationships, she wrote. If, however, the objectives of the legal fraternity are professional in character, then I have a deep concern over the exclusion of women law students from your membership. According to the National Bar Association at the time, there were only 59 Black women lawyers in the U.S. Given this small number, Murray said, it was ill-advised to use the same policies of exclusion in membership which are applied against us by the majority group. The fraternity refused to revise its membership policy, and Murray responded by outperforming her peers in class. She had entered law school preoccupied with the racial struggle and single-mindedly bent upon becoming a civil rights attorney, but she would graduate an unabashed feminist and take on sex discrimination, or Jane Crow, as she called it, as well. Murray coupled her excellence in the classroom with activism in the community. She co-led the Howard University student chapter of the NAACP's demonstration against segregated eateries in DC. She penned opinion pieces for several news outlets and represented the U.S. at the International Student Assembly. She graduated in 1944 with the expectation of attending graduate school at Harvard Law, as previous top students from Howard had done. But this was not to be. Her application was rejected, this time not because of race, as was the case with the University of North Carolina, but because of sex. Murray made a gallant appeal to the graduate school and the faculty at Harvard. Eleanor Roosevelt pushed Franklin to write Harvard's president on Murray's behalf, and he did. However, it was all to no avail. Harvard would not admit women law students until 1950, and the first African American woman would not be admitted until 1953. Undaunted, Murray would earn the Master's of Law from UC Berkeley in 1945 and the Doctorate of Juridical Science from Yale in 1965. She was one of the most highly trained legal scholars in the nation, irrespective of race or sex, yet there was never a list of bidders for her services. She always had to scramble to make a living. She did land several significant appointments. Among these were Deputy Attorney General for the state of California, briefly, staff attorney with the American Jewish Congress, lecturer and specialist in constitutional and administrative law at the University of Ghana, associate attorney with Paul White, Rifkin, Wharton, and Garrison, and she finally earned a professorship at Brandeis, where she was named the Stolberg Professor in Law and Politics, and she was a consulting attorney with the Equal Employment Opportunity Commission. She maintained a private practice here in New York City, which became her adopted home for a decade. The post Murray coveted most was an appointment to the U.S. Supreme Court. And on September the 18th, 1971, shortly after she heard a radio announcement of Justice Hugo Black's resignations, Murray sent a resume, a bio, a photograph, a copy of one of her recent law review essays, along with a cover letter to President Richard Nixon. She suspected that he probably had a replacement for Justice Black in mind. Nevertheless, she took the unprecedented step of introducing herself. I am, she told the president, a constitutional lawyer whose specialty is human rights, a Negro woman, 60 years old, with a good heart and health, accepting the normal wear and tear of one in her 60s. My religious affiliation is Protestant Episcopalian. I am a registered independent Democrat who regularly splits her ticket to vote for qualified candidates. My family background numbers as high as 7 generations of loyal citizens to the U.S. My political background and activities have been thoroughly canvassed by a special White House FBI detail in 1967. And while it is colorful, no pun intended, it is a loyal background, and I am not ashamed of it. My legal models and heroes and heroines include, but are not limited to, Charles Sumner, several Supreme Court justices, including Brandeis, Cardozo, Harlan, former law professors, William Hastie, Spotswood Robinson, Barbara Armstrong, Thomas Emerson, and others. Murray closed her letter with 2 important paragraphs. I do not presume to think that I am more qualified than other candidates you are presently considering, she wrote. I merely want to be given consideration along with the rest in accordance with your avowed policy of equal employment opportunity without regard to race, color, religion, sex, or national origin. It should be of passing interest, she added, that I represent the largest group of minority status in the United States, namely female. The court would be more representative of the composition and interests of the population of the United States if a qualified woman were appointed. My application is to forestall the popular misconception that no qualified women applied or are available. Murray's goal in writing Nixon was twofold. First, she truly wanted consideration, even though she knew she was an unlikely candidate. In 1969, the Senate had confirmed Nixon's nominee, Warren Burger, to the High Court, but it had rejected 2 later nominees, Clement Haynsworth and G. Harold Carswell. Nixon understandably wanted a successful candidate this time, and an African-American woman, no matter what her credentials and background, would have raised innumerable obstacles for the administration. This was, after all, a full decade before Sandra Day O'Connor would become the first female Associate Justice, and Thurgood Marshall had joined the court just 4 years earlier. Murray's second goal was to bring the absence of women from the High Court into a national conversation by highlighting the fact that women's exclusion was inconsistent with a national policy of equal employment opportunity, which she argued is applicable to the Supreme Court as it is to other areas of employment. It is hard to know if Nixon or his team gave Murray or any women serious consideration. What we do know is that his replacement for Justice Black, Lewis Powell, was confirmed by the Senate with a vote of 89-1. There is, however, good evidence that Murray succeeded in calling national attention to women's exclusion from the court. After the Boston Globe broke the story of her letter to the White House, other major news outlets followed suit. Several newspapers interviewed women lawyers and representatives of women's groups who submitted a list of qualified women to the president. Of particular importance was an October 22, 1971, front-page story in the New York Times with the headline, "President Bypasses Women for Court. Talent Pool Small." Nixon and his staff argued that only 2.8% of all lawyers were women. Thus, the president had a small talent pool to consider, and only a handful of these women were at the top of the legal profession. Women's groups and their supporters disagreed with the president's reasoning. They argued that discrimination and not sheer numbers was the reason that women were not at the top of the legal profession. This discrimination was evidenced, they said, by the refusal of many of the most prestigious law schools to admit women, the refusal of many law firms to hire women, the practice of directing women into low-status fields within the law, or to doing research and writing briefs for the men in the firm, the refusal of law schools to hire women professors, and the exclusion of women from appointments to lower court judgeships as well as clerkships for federal judges. At the time this article appeared, only Thurgood Marshall reportedly had one woman clerk. While the women interviewed for this article acknowledged that there were signs of progress, such as the growing number of women in law school who made higher scores on the admissions exams than the men, pressure on law schools to abandon their all-male admissions policies, and so on, the reporter found that women lawyers of all ages said that the main question they were asked when they were interviewed for jobs with law firms were who they intended to marry, or if they were already married, when they expected to have their first baby, and none could remember being asked whether they intended to return to work after they had children, though most did and do. Murray's letter also sparked interest in her. She was invited to do radio and television interviews, whereas groups such as the National Women's Political Caucus and the National Organization for Women were pleased that the issue had been raised, and progressives such as Congresswoman Bella Abzug endorsed her action. Murray also received letters from people who were not pleased at all. For example, a woman from Michigan wrote, "Dear Dr. Murray, regarding your letter to President Nixon offering yourself as a candidate for the Supreme Court, I thought it was more modest to accept an appointment by the president. I'd never heard of anyone offering themselves for such a high position. You evidently don't have a sponsor. Dr. Murray, forgive me for being blunt, but we don't need any more radicals on the Supreme Court. And since Brandeis has been a hotbed of the radicals, I don't think we need you. I consider both Brandeis and Harvard the cause of many of our troubles today." 5 years after Murray wrote this letter to Nixon, she answered the call to the ministry. As a priest, she would continue to advocate for social justice and to support the efforts of her sisters in the law. In looking back at Murray's contributions, the list is long and our time is short, but I'd be remiss if I didn't begin my brief comments with the Brown v. Board case, in which the Supreme Court ruled that racial segregation in public schooling was unconstitutional. When Murray read the brief that the NAACP legal defense team used in the Brown case, she knew that the argument had a ring familiar to a paper she had written a decade earlier in a civil rights seminar at Howard University Law School. She was astonished to learn in casual conversation with Spotswood Robinson, a former professor who had been a member of Thurgood Marshall's team, that NAACP lawyers had used her essay, should the civil rights cases and Plessy v. Ferguson be overruled, in preparing their brief. Murray had argued in that essay that segregated schooling placed Black children in an inferior social and legal position. Finding no legal precedents to rely on, she had drawn upon the research of psychologists who had demonstrated that through doll studies that segregation did violence to the personality of the individual affected, whether he or she was white or Black. It was an argument that moved Chief Justice Earl Warren, who said in the court opinion that to separate Black children from others of a similar age and qualification solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to be ever done. There is no question about the existence of that paper, the argument, and the importance of her work. I try to read that document every time I visit her archive, for Pauli Murray, in my view, is co-architect of the landmark Brown decision. Murray's contribution to women's equality are reflected in the influential law review articles she penned with respect to sex discrimination in employment and education. The first of these was her master's thesis entitled The Right to Equal Opportunity in Employment, published in the California Law Review in 1947. 45, let me say that again, 1945. She's writing a law review essay looking at sex discrimination. That marked several milestones. It was her first law review essay. It was the first essay ever published in a law review by an African-American woman, and it was the first law review essay on sex discrimination and employment. She published several additional essays over the years on issues having to do with discrimination based on sex in the law. She also wrote several monographs on civil and women's rights that would have lasting value. Take, for example, a document she wrote in 1962 at the request of the Committee on Civil and Political Rights of the President's Commission on the Status of Women. That monograph, entitled A Proposal to Re-examine the Applicability of the 14th Amendment to States' Laws and Practices which Discriminate on the Basis of Sex per se, was a comprehensive analysis of judicial decisions on cases involving legal distinctions based on sex. In this document, Murray stressed the need for reconsideration by the courts in light of the contemporary data and circumstances of states' laws and practices that discriminate solely on the basis of sex. In her view, the doctrine of sex as a basis for legislative characterization set by the courts in the early 1900s was as pernicious as the racial doctrine of separate but equal, which the court had overruled. Murray urged the pursuit of litigation under the 14th Amendment as a practical intermediate step, but she did not dismiss the need for an Equal Rights Amendment. Murray wrote another document of lasting value as part of an 11th hour campaign to ensure that sex remained a protected category in the 1964 Civil Rights Act. Before the final vote on this bill, Virginia Congressman Howard W. Smith introduced an amendment that added sex as a protected class in Title VII of the bill. Because Smith had used his power as chair of the House Rules Committee to prevent civil rights legislation from coming to the floor for a vote, Liberals viewed his support for women's rights with cynicism. Smith's real motive, some believe, was to induce fellow representatives to vote against the legislation by pandering to male chauvinism. Nevertheless, the sex provision ensured that millions of employed women, irrespective of race or class, would be covered by the legislation. At the last minute, Senate Majority Leader Everett Dirksen threatened to amend Title VII by eliminating sex as a category. In doing so, he mobilized a national network of women in Congress, the Federal Civil Service, and professional and service organizations, many of whom thought that they needed to get word to important figures that this was really important. And so they asked Murray to draft a memorandum, which she did, supporting the retention of the amendment to H.R. 7152. And that document was duplicated and dashed off to Dirksen, congressional leaders, and Attorney General Robert F. Kennedy. Murray argued in that memorandum that there were few, if any, jobs for which an employee's sex could be considered relevant, and that the sex amendment would strengthen the proposed Civil Rights Bill, as well as the recently passed Equal Pay Act. Title VII, without the sex amendment, she pointed out, would benefit Negro males primarily, and thus offer genuine equality of opportunity to only half of the potential Negro workforce. Murray also sent her document to Lady Bird Johnson with a cover letter which said that women were being intimidated from speaking out on this issue on the ground that by doing so, they will endanger the larger civil rights legislation. As a Negro and as a woman, Murray argued, this point of view is erroneous. And she asked the First Lady to discuss the matter with the President. Murray was elated when word came that from Lady Bird Johnson's social secretary, indicating that the First Lady had checked the matter out, and that as far as the administration is concerned, its position is that the bill should be enacted in its present form. On July the 2nd, 1964, President Johnson signed the historic Civil Rights Act at a ceremony in the White House. The president acknowledged the contributions of the Reverend Dr. Martin Luther King, who was present as a guest, by giving him the first pen used to sign the bill. For Pauli Murray, there would be no souvenir pen or a White House invitation, but she would forever cherish the notes of appreciation from fellow women activists who credited her with the ultimate successful passage of Title VII of the Civil Rights Bill, with the protection for women's employment. Of no less importance than the writings I've mentioned is Murray's co-authorship with Dorothy Kiernan of the ACLU brief for White v. Crook, a civil class action suit challenging an Alabama statute restricting jury service to males and whites. This was the first case in which a federal court relied on the 14th Amendment to rule a state law unconstitutional because of sex discrimination. Now, so what can we learn? What can we take away from Pauli Murray's life work? I'd like to suggest a few things. One is that the role of lawyers as witnesses and advocates for justice is vital to the preservation of human rights in our democracy. Two, that the voice and participation of women lawyers and others who come from the most vulnerable backgrounds are essential to the dialogue. Three, that it is important, as Eleanor Roosevelt advised, to channel anger and frustration in useful ways. When blocks were placed in Murray's path, she worked harder at preparation and strategy. She would withdraw to recover and then re-emerge and re-engage. 4, that it is important to speak out even if you are a solo voice. Murray used to say that one person plus one typewriter constitutes a movement. Had she lived in the digital age, that would be one person and a smartphone. 5, that mentoring, however best we can do that, keeps the pipeline flowing. Murray shared her training manual from the Howard University demonstrations in the 1940s with the bus riders who went into the South in the 1950s. And this material surfaced again in the 1960s with the student sit-ins. Murray sent encouraging letters to junior scholars, including me, and she nurtured feminist organizations, such as the National Organization for Women, which she co-founded, and groups like the North Carolina Association of Women Attorneys, to whom she spoke at their first annual conference. We can also take away the notion that one's commitment to the law, no matter what one's role in it as an advocate, a judge, private practice, whatever that is not enough. One needs broad experience to enrich one's work and understanding of the human condition. I've heard that Justice Ginsburg has a passion for opera. For Pauli Murray, it was poetry. She once told an Associated Press reporter who interviewed her about the Nixon letter that her goal has been to integrate the poetic impulse with the precision of legal analysis. She also told Eleanor Roosevelt that there are times when a legal brief is inadequate to make the point. As a lawyer, Murray said she was bound by the facts, but as a poet, her job was to respect the truth. In closing, I want to leave you with 3 lines from a sermon Murray delivered in 1978 entitled The Last Judgment. She said, "Our actions have a lasting significance and consequences that are felt throughout eternity. Therefore, we need not despair because we seem to fail or cannot see the fruition of our efforts on behalf of others. If we build with love and compassion, we can build with hope." I want to thank the bar. I want to thank Justice Ginsburg, and I want to thank you, this lovely audience, for giving me the opportunity to pay tribute to the Reverend Dr. Pauli Murray. Thank you. Thank you.
Thank you, Professor Bell-Scott, for that tremendous storytelling of a life well led, a person whose clarity and force of vision was captured by the clarity and force of your remarks about her. And I think all of us come away with the sense that that it was Pauli Murray's capability of seeing what all should have seen and articulating what all should have been able to understand that makes her story so distinctive. And thank you. We're all richer for your telling it. Thanks to all of you for coming tonight. A wonderful celebration, and thanks to Justice Ginsburg for her remarks and her presence here with us.